Hi, good evening. Welcome to another episode of Lawyer Lens. This is Steve Rose with you again. And I wanted to take this opportunity to talk about the, the civil suit, the rape case involving the punter who was recently drafted by the Buffalo Bills, Matt Araiza, aka some know him as the punt god, so to speak, because of his ability to punt the ball or kick it from a fixed position up in the air for about 5 seconds for a distance of sometimes over 80 yards. An incredible leg. He was called a punt god, and he was drafted, which is rare for a punter sometimes in this day and age to be drafted. He was drafted to the Buffalo Bills, who are considered a contending team, so it's a team in the national spotlight. Really, any National Football League team is in the spotlight because it's the right now the most popular sport in America. I mean, just for a quick example on that point, I heard that the other day the preseason Steeler game preseason had higher ratings than all of the NBA regular season games that were shown on Christmas of last year, which is a huge viewership day for the NBA. And one singular meaningless NFL preseason game beat the ratings of those NBA games. And NBA is no slouch when it comes to viewership. So we're talking about the power of the NFL, and thus every case is magnified. But I really wanted to take the opportunity to discuss this case coming from kind of what I feel is a different perspective than a lot coming to this in the realm of public opinion. I'm an attorney, as I've said in other videos. I've practiced law for well over a decade in both state and federal courts, in particular with regard to violence against mostly in the case of women. I have volunteered in the past to assist in their cases. Victims of domestic violence. I've done a lot of research and I've worked with prosecutors before who have handled sex crimes cases. So I do come to this with some knowledge and I hope perspective that really shines some light and helps at least open a conversation about what we're talking about here. There are really many aspects to this story, and many have heard about it already. It was in Good Morning America. It was covered on CBS, for example. I'm sure many other channels, and especially the ESPNs of the world, have all covered it. And as you've probably heard, if you've been following the cases, the Bills, within 48 hours of the filing of this civil suit, earlier this month, if I remember, it was maybe August 25th or maybe a few days prior that the lawsuit was initially filed in California. So this touches a lot of things here that I wanted to discuss. I wanted to discuss the well-known concept of innocent until proven guilty, where that's applied, how such differs in a court of law than as opposed to a business. What's right in a criminal court? What's really right in a civil court? What's right for a business? And when I say what's right, I mean what's right under my opinion. But reasonable people can differ, and if you disagree with anything I'm saying, I welcome all perspectives. Please feel free to comment, and I'd be happy to converse. I most certainly, I'm not satisfied with echo chambers. I like conversing, and especially with people with different perspectives, perhaps with whom I can learn from. And I just want to say, I don't want anyone to come out, if you happen to watch this video, I don't want anyone to come out with And forgive me if I don't communicate this well enough throughout, but I'm not here to advocate for anyone. I'm not going to stand here and tell you I believe every allegation from the accuser, the alleged victim in the complaint. And I'm not going to come here and tell you I am in any way whatsoever defending the accused punter, Matt Araiza. I simply do not know what happened. Nobody knows exactly what happened yet but the people involved. We simply have a complaint, and we will let the facts get substantiated over time. But I will discuss my thoughts on them, and if he is exonerated, if he is found to not have met the threshold by any jury, or if there is a settlement, I can't have any opinion that he's guilty because such hasn't been substantiated yet. If he is found to have done these awful things, if you read the complaint, it's just awful and horrific, and she seems credible, and it's an incredible story. And if quite frankly, if he's guilty of any of this, he should pay damages within the civil suit, and then hopefully a criminal case comes by and he fries for this, because anybody who's guilty of a forcible rape or any kind of like crime is the worst of the worst and deserves what's coming to them. So I'm not defending anyone. I simply do not know all of the facts yet. We have allegations, and they must be parsed through and substantiated through the course of this case. So we have many avenues to touch from. We have a civil suit. We have, maybe we're going to have a criminal action. I put a question mark because we simply don't know that yet, and I'll go into that. We have the National Football League and what you do from a business perspective, and what from a business perspective, and innocent until proven guilty. When is this applicable? I'd like to actually touch on the bottom first, because you see a lot of people saying Bill should have gotten rid of him the second they heard about this from the lawyer on the phone, even before the suit was filed. You have people who are going on Twitter, going on Facebook, on all social media, Instagram, you name it. They're going on after looking, maybe not even after reading the complaint, after just hearing about the allegations. They're saying, this is a criminal, he deserves what's coming to him, the worst of the worst punishment he should get. He committed a horrific crime. You have people who are saying, innocent until proven guilty. We shouldn't be hearing about any of this. We have a presumption of innocence in our mind and our eyes. He should not lose his job. He should not lose anything. He should just, everything should just go according to the way it was. And only after a jury of his peers finds him guilty of a crime or having liability for anything should we judge. And where is that applicable? And then you have, like I had written, civil suits, criminal actions, the NFL, etc. So And this cuts into another topic, the Me Too movement, Believe All Women, etc. And I'd like to touch base on this because I feel like with many things, you have a bad situation in the past, you have improvement in the future, differing perspectives, and then quite often, sometimes you can go too far the other way. Like for example, you had the robber barons in the early 20th century running sweatshops, for example, all over Manhattan and etc. And you had unions created in order to assist workers and give them the leverage that they needed in order to deal with, in order to be able to collectively bargain and have rights against employers who were in large part using abusive practices and exploiting the workers. But while in many cases unions are still quite effective and they do a great job and they are really good for workers, in some cases, and maybe even often though, unions today have gone too far the other way, and in some cases employers today, while some of them are still very abusive, don't get me wrong, but some employers are also abused, and they don't have the ability to get rid of a worker who is taking advantage or not doing the job despite being treated well and getting paid well. The worker's not doing the job because in some cases unions have too much power. And this is an example of a remedy going the opposite way too far today, so that now you may have in some cases the employer getting the short end of the stick as opposed to the employee, which was always the case almost always prior. And with regard to allegations, what you used to have, and forgive me if this isn't a perfect analogy to unions and etc., but what you used to have with, it was quite often the case, go back 40, 30, 50 years, 60 years, etc., you would have an allegation. If a woman would even be daring enough to come forward with an allegation, you would have an allegation, quite often a power, like let's say a student body if it happened in a school, or a power structure within a job. The sentiment would be to look down upon that woman, like she brought it on herself, or we don't believe her, or even worse, and this probably happened quite often, there was an apathetic view of it. We don't take it seriously. We're not going to listen to you, or good luck with that complaint. You're just trying to take down this man's life. You would have people in society looking down on that woman, accuse her often. If it was a small town especially, perhaps the entire town might look down on that woman. You would have an instance in which it would be only seldom the case that a woman would come forward with any complaint of abuse, whether sexually or any other kind of abuse. And then once you would have that complaint, you would have either a slow-acting administrative body or a slow-acting employer or a really slow-acting police and judicial system. Women were not, their cries were not taken seriously. Their complaints, their pleading, they weren't taken seriously, no matter how credible the complaint was. And we're fortunate today that almost unanimously, you're always going to have extremes, but for the most part, if a woman makes an allegation that she was abused or attacked in any way, for the most part, the reasonable standard person today, I'd like to believe anyway, will take the allegation quite seriously. And that's the way it should be. But there's a difference between taking an allegation seriously and forgetting about an allegation and then just saying the blanket statement, you must believe the allegation, or i.e., you must believe all women. I think the term believe all women is wrong, and it's actually anti-woman, because a woman is quite capable of lying too, and by saying believe all women, you're essentially saying a woman can't lie, and then you're essentially saying that a woman can't do what a man can do. A man can lie, a woman can lie. A man can tell the truth, a woman can tell the truth. Women are every bit as capable of doing the right thing and doing the wrong thing. It goes both ways, and this is obvious. But we have to be careful with believe all women. No, I think you take a woman's allegation, always you take it seriously. And so you devote the appropriate resources toward it, and you take it extremely seriously, and you investigate it right away, and you spend time on it, and you try to achieve the truth, and from there achieve justice for the woman's sake, if the allegations are substantiated. But that's the key word. You have to substantiate the allegations. You can't just say, I believe the woman, and thus this man has to be accountable. No, there is a chance that the accused did not do what the woman said. And it's not even, sometimes the woman isn't even lying in that case. You know, there could be forced intoxications involved, there could be drugs slipped in drinks, there could be hazy memories. Sometimes a woman just gets it wrong as far as who is accused, but it doesn't mean the woman wasn't attacked. Quite often, though, the woman is right. We don't know. But the difference from today and in decades past is we largely should, and most people are of the mindset, I think, that you take the allegation seriously. And so now, once you have the allegation, and even though you've taken it seriously, yes, you still follow innocent until proven guilty. But now you have people online and in these various forums saying, totally, the Bills made a mistake. They should not have let go of Matt Araiza. You have a presumption of innocence, etc. But that's not necessarily true either. Yes, you presume innocence until guilt is proven. But where is that presumption held? That presumption is held in a court of law. That assumption is held when, for example, criminal charges are brought. Then you have innocent until proven guilty, and you have to be proven guilty under a standard of beyond reasonable doubt in a criminal court. Of course, in a civil court, it's a different standard. It's more likely than not, but there is still a standard that you have to meet, and there is that, until you meet that standard, there is that presumption of innocence. So, yes, innocent until proven guilty when you enter into the court case in that realm. So until proven guilty up to the applicable standard, whether it's civil, whether it's criminal, yes, there's a presumption of innocence. But with regard to a private business, the Buffalo Bills are an at-will employer, and they don't need a guilty threshold to let go of a player. They have every right to do it. Now, you might argue, okay, yes, the Buffalo Bills technically have the right to get rid of him, but it doesn't mean it's right. Okay. But here, look, a civil case, it could go on for a year, it can go on for 2, it could go on for 5 years. In a year or 2 or 3, or maybe never, we don't know, a criminal case might be brought. The Buffalo Bills are a very public business, okay? They have a right to look after their bottom line. They have a right to look after how the public perceives them. And it is quite logical for a business while it's running under the public eye, while it's trying to sell merchandise, while it's trying to be marketable to all kinds of people, it's not exactly easy or the best marketing strategy to house a player on your team that is an accused rapist, even if he might not have committed rape or the other crimes or counts in the complaint that we will go into. Still, there is a chance that he did it. He has a pending case against him. It is a distraction for a business, and thus it wasn't wrong for them to say that's bigger than football. He should concentrate on that, and he shouldn't be on this team. Now some will argue that the Bills will go the other way and say that the Buffalo Bills took too long to release him, and the lawyer told the Buffalo Bills almost a month before the case that this was coming. But we don't exactly know what the lawyer for the accused told the Bills. Here you have somebody who was working his whole life to get onto the team. They had been training him since the draft for several months. Obviously, relationships were built. So I can see a team not axing a guy and firing him right away based on a singular phone call from a lawyer where we don't know how many details. And you know what? It's quite likely that he barely gave any details because attorneys prior to suits don't usually like to tip their caps. We don't know what was told to the Bills, and we do know that only the attorney reached out to the Bills. Law enforcement hasn't said anything to anybody, as the LA Times made clear. They haven't released any details. So you're the Buffalo Bills, you have a phone call from an attorney, you're probably parsing through things, you're probably trying to interview people who are at the scene, which was San Diego State University. This takes time. Now you have the civil suit filed. The very next day, the team is on a plane to Carolina to play the Panthers in the preseason game. So they let go of him 2 days after the filing of the civil suit. I could see the Bills taking that time and trying to look at this first. Their messaging was bumbled. They put out a message that they had done a thorough investigation, which is nonsense because something like this can't possibly be thoroughly investigated in such a short time frame. Sometimes it could take years to parse out these kinds of facts. So they didn't message it correctly. They should have probably just released him when the civil suit was filed. The team did not act perfectly. But at the same time, though, it was reasonable, I think, that the team let him go 2 days later. Even though he has not been proven to be guilty of anything, it's quite reasonable for a public entity who does not have to follow the innocence until proven guilty standard to look after their bottom line and their marketability, and while the case is pending, not have him on the team. Now, let's say it's shown that the accuser, now named Jane Doe, in the case, was wrong about him. Then I'm sure the Bills would reach out, or he would reach out to NFL teams, and he could be on an NFL team again. That could be in the future. But while this case is pending, I wouldn't blame any business, especially one in the public eye that works on selling merchandise to the public, not employing an accused rapist. So that's the innocent until proven guilty under the perspective of the NFL, and that's my perspective on why that doesn't always fully apply, and it's different. You have to parse whether you apply it in court where it's an absolute must, or you apply it in the business world where there's a different standard. At the same time, like I said, you do have a difference with a civil suit and a criminal action. Now, according to reports, this incident occurred, and the complaint alleges that this incident occurred last October. And we know from the complaint, at least the complaint alleges, and the complaint isn't going to make this up, that the accuser went to the police the very next day. So you have a complaint with the police since October of last year, and to date, a criminal action has not been opened. There hasn't been an indictment sought against Matt Araiza and the other two who are accused of these horrific crimes. An indictment, you take some evidence at least to a grand jury that meets in secret. It's not a public event, and the grand jury decides if you have enough to indict or to bring a criminal action. It's a lot lesser of a standard than guilty beyond reasonable doubt. There's the old saying, you can indict a ham sandwich if, even with a little evidence, if the prosecutor wants an indictment, they'll get an indictment. According to reports, presently, the police have turned over what they have to the local district attorney in San Diego, and the district attorney is deciding whether or not he will bring forth charges, i.e. he's probably thinking, or she's probably thinking, do I have a case? Can I present this to the grand jury? Even if I get an indictment, will I have a chance at a criminal conviction, or do I have the leverage to negotiate some kind of plea? Prosecutors, they say, win 97% of the time. It's not because they're winning all these cases and they're the best lawyers out there. It's because the vast majority of cases plea. And the reason why they plea is because prosecutors usually have a bunch of charges and evidence of those charges, and they have a lot of leverage. If there's no leverage, then they can't plea. If they can't plea, they likely lose, and if they likely lose, they're not bringing the case. As prosecutors are very, very cognizant, and they care a lot about how many times they win and lose in court. So right now, the district attorney is deciding whether or not he has enough for criminal action. So as of now, we have no criminal action, but we have a civil suit brought against Mr. Araiza and you have two other football players who are playing with Matt Araiza at San Diego State. And just to touch on the difference again, in a civil suit, you have to show more likely than not that the allegations in the complaint are true to meet each cause of action. So it's different than the beyond reasonable doubt stage. Usually you'll hear a criminal case has either started or finished prior to a civil suit being brought. Most famously, if you recall, the O.J. Simpson criminal trial was followed by the civil suit in which O.J. was ordered to pay damages even though he wasn't found guilty in the criminal trial. It's a perfect illustration of the differing standards that are applied in each case. It is a little, it's not often that a civil action will be brought in the absence of a criminal suit being brought at all. And the reason for that is, like I touched on before, and there could be other reasons too, but a reason that I would think is the standard to get into criminal court, i.e. to get an indictment before a grand jury, is really low. And so in a civil action, if I'm Araiza's counsel, I would argue even the district attorney hasn't so far believed that anything happened. They haven't even secured an indictment against my client yet. No criminal charges have been brought, despite this all being reported to the authorities the very next day. So it is unusual, and I'm sure that the talented attorneys on both sides will have their arguments, and I'm sure there will be reasons why. But I just wanted to touch on the order that it usually is and how this case may be a little unusual. But with regard to the civil suit, I'll walk through the story, which it's almost hard to say. It's like it's horrific. It's like out of it's like out of a movie even. It's just really bad, and I can't imagine someone completely making this up. But we don't know who or what actually happened, but I'll talk about the case. So the accuser, who is named in the action, her real name is not put in the action, Jane Doe. So at the age of 17, she attends a party off campus at a house near San Diego State University. At that party were three of the football players at the time on the San Diego State team. I believe two of the accused are still on that team, or at least one is. And one of the accused is Matt Araiza, who was on the team at the time, and like I said, was drafted in last year's draft by the Buffalo Bills, National Football League. And the team was having a lot of success, and it's not a university that's really known for having big time or successful football teams. So you have these football players at an off-campus party. The defense in this case alleges that this was Matt Araiza's residence. I've heard on interviews that that is disputed by Matt Araiza's attorney. Regardless, that doesn't really matter in the scheme of things as far as the allegations and what it takes to prove, the steps it takes to prove each allegation. But the accuser, Jane Doe, she was at a Halloween party. I believe it was a Halloween party last October at this off-campus house. And she alleges that she was approached by Matt Araiza. They walked outside. She alleges Matt Araiza gave her a drink. And she drank the drink and felt that she was under the influence of some foreign substance, that he asked her to perform oral sex on him in an alleyway on the side of the house, that she did, and then he penetrated her on that same, right outside of the house, right on the side of it. And then after that, while she was still in her drugged state, he brought her in to a room with two. I don't like talking about this, but she brings her. She's brought into a room where two of these other football players allegedly are standing there. She's put face down, and they take turns gang raping her. And there are pictures of her all bruised up that were released, and there are allegations that her earrings and jewelry were ripped off of her body. And she alleges she left her phone there, and that her phone app traced the phone back there, and she knocked on the door and said, "I was here, I need my phone." And the and the man who answered said, "Oh, we know you were here," in a joking way. And it's quite a disgusting, it's quite disgusting, and it's hard to even read. It was an 11-page complaint, and these are really serious allegations, and a lot of people are saying that she's credible for taking, as she took this to the police the next day. I'd argue that she would be credible even if she didn't. There's no reason to think that she's not credible. I mean, quite a few. I imagine if I can imagine that after going something through so horrific, it would be really hard to relive it right away. And I wouldn't blame somebody or think that they're more likely to be lying if they didn't go to the police the very next day. So that's not necessarily a disqualifier. But here she did go to the police the very next day, and she did a rape kit, which I'm sure it's just hard to go through. right after or any time, and it's just intrusive, and it's a really difficult process. And she brings this case, and from what the lawyer of Matt Araiza has described in a couple of interviews, he keeps on touching on there was no forcible rape, there was no forcible rape. It's quite obvious, and especially in the Good Morning America interview where they asked him this and he didn't say anything, it was quite telling. We know for a fact that Matt Araiza did have sex with this woman. The question is, did the forcible rape occur? Now, you might echo what a lot of people are saying, a lot of people are saying on Twitter or on various shows. Wait a minute, that's a crime. He already admitted to a crime. Why? Because she was 17 at the time of the incident, and he was 21. If he had sex with a 17-year-old, well, that's statutory rape, right? A cursory review of Google, you Google California statutory rape, Penal Code 261.5, I believe. I'm just looking at my notes here. Yes. So Penal Code will say the age of consent in California is 18. Oh, well then it's finished. We at least know that he committed a crime and he admitted it, and people are repeating this over and over again, but that's just not true. Under California law, statutory rape is not a strict liability statute. What do I mean by strict liability? In many states, no matter what, if you are not a minor and you have sex with a minor, no excuse whatsoever. Strict liability. The act of sex is the crime. Now, there could be mitigating circumstances as far as how much prison time there is, or if it's a misdemeanor, or if it's a felony. Like, for example, there's probably a difference in those strict liability states. If a 19 and a 17-year-old who already have a relationship have sex, then a 35-year-old and a 15-year-old. There are levels to it, but that's just what crime or level are you guilty of, but you are guilty of something if it's strict liability, i.e. the act of sex between a minor and a not minor is all you need. But California is not a strict liability state. In California, there are defenses to this, and relevant here, there is a defense to statutory rape if the accuser is at least 16 years old, and the accused had a good faith, reasonable belief, and this is he has to have a subjective good faith belief, and that belief has to be objectively reasonable, that she was not a minor, then that's a defense. Then it's not statutory rape. And if you look at the interviews with CBS, with the various stations locally and on Good Morning America, Matt Araiza's lawyer specifically mentions over and over again that at the party, the accuser, and he alleges to have several witnesses to this, the accuser was telling everybody that she was attending a local community college, that she was not a high school student, which she really was at the time, but that she was a community college student, and she was not representing herself as a minor, but as someone who was at least 18 years old. So if they were ever accused of statutory rape, that would be the defense that they would likely put forth, that yes, there was sex, but he had a good faith belief based on her actions, and that she was not a minor. And that would be a defense. So it's not a true statement that he admitted to a crime. That's just not true at this point. I'm not saying he didn't commit a crime. He may have committed everything that he was accused of, and then at that point, as far as I'm concerned, the guy should fry. I have no sympathy for anybody of that ilk, and I am taking her very seriously. I am not defending him at all. I'm simply saying that a statement that he already admitted to a crime, no, he didn't already admit to a crime. This is something that has to be parsed out and fleshed out in court. And also, if you look at the civil suit, now complaints are amended all the time and things are ended, but the civil suit, while it alleges that she said that she was in high school, none of the causes of action that he is sued for is actually with regard to statutory rape. The causes of action, if you look in that complaint, it cites penal code and civil code statutes that have to do with, so the complaint has a cause of action for the imprisonment of someone against their wishes, for sexual assault, for forcible sexual relations, for violation of the Ralph Act, which is a civil rights act that protects certain classes, including women, from certain egregious behavior, etc. So the causes of action go more toward her being forcibly attacked. There isn't a specific cause of action in the complaint for statutory rape, but even if there was, and that could be brought at a later date if the court allows an amendment, etc., specifically for that. But even if there was, at this point, Matt Araiza has not admitted to a crime, and we do not know yet if he committed that crime or any of the heinous acts that are alleged in the complaint. We don't know that yet, and it's important. And this goes back to, in the court of law and in society, people should not be calling Matt Araiza's parents and giving them death threats. Matt Araiza lost his job, which I think was the right thing from a Bills perspective, although they didn't handle everything correctly. But it's easy to say that I wasn't them, and they were probably going through a lot too, being handed all of this after they're trying to work on their football team, and they have Super Bowl aspirations, and the lawyer calls about their punter. They were probably caught off guard, or maybe I'm extending them too much of the benefit of the doubt, but they had every right to cut him. But at the same time, we still don't know what he did, or if he violated any laws, or if he did what she accused him of doing. We need to let the case run its course. While in many, many instances, the accuser, the woman in many cases, has been ignored, and she was right, and there hasn't been justice. There also has been, unfortunately, cases where the accuser was given the benefit of the doubt, and the accused lives were made a living hell, and then afterwards it was found out that they were completely innocent. And there are many cases. I mean, people recall the Duke Lacrosse case. These affluent men were just the bane of society, and they were attacked from all ends and lost all kinds of money and opportunities, and they were slandered, and it turned out that the allegations were not true. So we have to take, unlike the past, we have to take every allegation seriously, but it's very important that we understand that this is a complaint. Nothing has been proven yet. We don't have evidence yet. We do not have, contrary to public outcry, we do not have the admission of a crime at this stage. We must allow the case to take its course. Now, in many of these cases, there could be a settlement. And then, well, a settlement says, a lot of people will then say, well, if there's a settlement, then there's automatically guilt. That's not true either. Most of the time, I've done many settlement agreements myself in a variety of cases. Most settlement agreements are confidential. There's a confidentiality clause within the agreement. And quite often, like I'll tell you from my own personal perspective, like for example, in a civil case, I was representing a flooring company, and I knew from a fact from my expert, who was an architect and a flooring expert, that my flooring company did not do a single thing wrong with the house. And they were sued by a homeowner for allegedly putting forth a bad flooring and installing it incorrectly. And I convinced my client to settle, because settling the case, it was just a cheap way to get out of the case. They didn't have to go through further expenses of the case. They didn't have to go through their company's name being within a suit. There are many, and they can just go on, and sometimes you do a cost-benefit analysis. Sometimes, if you're Matt Araiza, you might want to get back into the NFL as soon as you can, so that you can earn that game day paycheck. So you might think, well, if I didn't do this, but if she would take $100,000, here, I'll pay her to make the suit go away. And that just because there's a settlement, it doesn't mean that the accused is guilty of anything. But in a settlement, sometimes the accused could be quite guilty. The point is, we don't know. And that's the overall point here. We must take these horrific allegations really seriously, and looking at and I can't help but feel sorry, and I have a daughter of my own, and I see these bruises, and I want to throw up from these pictures. I really do. And I want this to be taken seriously, and I want it to be investigated with a fine-tooth comb. But that's what we need to allow to happen here. We need this court case to go forward. We need discovery. We need motion practice. We need subpoenas. We need witnesses. We need testimony. We need affidavits, declarations. We need evidence. And only with evidence, only with adjudication on the merits of the case, only when the facts are substantiated should we then make judgments. If the facts and the case results reflect that it's more likely than not that Matt Araiza did these things to her, then he deserves everything he's going to get as far as damages from the civil suit, and as far as how society will view him. If a criminal action is brought, then and he's found guilty, then he goes to prison, and then certainly he deserves everything he's going to get. We simply have to take the allegations seriously, and then we just have to let the system run its course. And I would urge to just reserve judgment. You can reserve judgment while taking the matter seriously, while giving all the respect to the accuser, and seriously investigating this. The two are not mutually exclusive. A lot of people just quickly like to go and make. They say the empty can rattles the most. You have a lot of people who don't know much, and they're just making a lot of noise about issues that are quite serious, issues in which if they were involved, they would not want people like them making the same statements all over in public. And I guess social media is an avenue for that, because you're nameless and you're faceless in many cases. So I would just urge people to reserve judgment. If you really want to have an opinion, to really look into it, to read, to see what needs to happen, to see what is actually substantiated and what is not. Don't look at a quoted complaint and say, oh, we have a recording of a phone call. No, according to the LA Times, you don't have any recording yet from any law enforcement agency. You don't have any transcript yet from any phone company. You just have what's alleged as a quote in a complaint, and complaints are wrong all the time. I'm not saying this complaint is wrong, this complaint could be totally right, but I'm just saying we can't jump to conclusions yet. We have to take it seriously, and we have to give it the attention it deserves, and we need to reserve judgment until we get all the facts. That's the best way you can respect the accuser, but also respect the process. I hope that this was informative. I hope that this was helpful. Please feel free to leave any comments, and I certainly welcome. I'm wrong all the time, as my wife can attest to, and I certainly welcome disagreement, and I welcome different perspectives. So please feel free to leave a comment, and I hope this was helpful. Thank you for joining me this evening. Take care.